pointing.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. Hearty welcome to Jnanarjane Empowering Excellence. Friends, today's Wednesday study circle, we have selected a very interesting topic and most relevant and most important for all of us. The topic is data audit in Personal Data Protection Bill 2019 and the current, the Information Technology Act 2000. Friends, all of us know how important data is. Currently, it is most precious, as everyone say. It used to be precious metal, was very precious. Now, data become much more precious than even precious metals. Friends, all of you know, in 2018, Flipkart valued more than $21 billion. And this year, more than 33 unicorns in India alone. What are their assets? Majority of their assets is data. Either they have some data with them or they have the capability to acquire more and more data. The deadly combination of data and artificial intelligence is taking over every business, including changing government. That's what people say. Even though I'm not expecting that, I heard that. So to that, I think enlighten us all this issue. The Personal Data Protection Bill 2019 was introduced in Lok Sabha by then Prime Minister Mr. Ravishankar Prasad on December 11, 2019. Almost 2 years now. Hopefully, this winter is going to be an act. It is giving a lot of details, where it is applicable, the obligations of data fiduciary, the rights of the individual, grounds for processing personal data, social media intermediaries, data protection authority, and what are the penalties, the crores of rupees penalties they have mentioned in the bill for people who are not misusing such data. So friends, a very important bill, which is going to be an act, and the currently what is available with us, the Information Technology Act 2000. On these two issues, a person having vast knowledge in this, a data protection and data governance consultant, Mr Vijayshankar Nagaraj Rao, more popularly known as Navi, has been a pioneer in the field of cyber law in India and also a pioneer in data protection, data governance, a professional based in Bangalore. Friends, he is Namma Bangalorean. Navi is a data governance consultant developing jurisprudence in the field of cyber law and data protection law. As a thought leader, Navi has pioneered several activities in India around cyber laws and data protection. He is the founder of www.navi.org and cyberlawcollege.com. He is the chairman of the Foundation of Data Protection Professionals in India, the premier organization in India dedicated to data protection. Navi has pioneered many cyber law related technology services such as Cyber Evidence Actual Center and online dispute resolution. In the field of data protection, Navi has pioneered through FDPPI, new certification program for data protection auditor or consultant, and has also introduced an exclusive framework, Personal Data Protection Standard of India, for the implementation and certification of organizations for compliance of data protection laws. Navi is a visiting faculty in number of educational institutions, including National Law College of Bangalore, Nalsar, Hyderabad, Raipur, and many other important law colleges. Navi is an author of many books, including Personal Data Protection Act of India and Concept of Theory of India, Theory of Data, theory of data. Two important, two or very, very best-selling books he has authored. With this very, very brief introduction, we are really fortunate to have him here to explain this very, very important act and bill. On behalf of Bangalore branch and on behalf of all the participants here, hearty welcome to Sri Vijayshankar Nagaraj. Hearty welcome, sir.
Thank you. Thank you.
Friends, you are the reason for this program. Week after week, every Wednesday, we meet 6 p.m. to 8 p.m. with various interesting topics for all of us. Today's topic is one such very, very interesting one. Hearty welcome to each one of you. Let me take a minute of yours to inform you about the upcoming program. Day after tomorrow, Friday, 26th November and 27th November, we have organized 2 days conference. It is on hybrid mode, available both on physical and virtual. Physically, we are conducting this program in the Institute Auditorium. The program is on charitable institutions and various other institutions like Section 8 company, societies, and many more. To understand in detail the various changes, including FCRA, the discussions involved on income tax, GST, FCRA, and various other statutes applicable, including CSR, Code of Governance, everything in detail we are discussing in the next 2 days on Friday and Saturday, 12 hours of learning. Eminent speakers are going to impart their knowledge. After a long time, after almost 18 months, we are conducting this physical program. I request all of you to register and participate, either physically or virtually. Friends, it is on 26th and 27th, day after tomorrow. Registration is open. Please register that program. Very, very interesting and very, very important. Lot of practice opportunity is there. Government is expecting lot of information from these NGOs. Every pie received by NGO, either from CSR or from any donation, and how they are spending that. Every pie government wants to know. They are going to renew. Re-registration is expected from them. I think that date is postponed to 31st March 2022. By that time, all the existing institution needs to re-register. And they have to comply regarding CSR filing. And various other information they have to file on a regular basis. To know all these compliances, to know all the latest developments in the charitable institutions and trusts, I request your branch organize this 2 days conference. I request all of you to register that program. And in the month of December 10th and 11th, again we have organized 2 days national conference on GST and indirect taxes. ICA president also agreed to attend that national conference. It is going to be in FKCCI auditorium. Again, it is going to be a hybrid mode, both on physical and virtual. Whichever is convenient to you, please register. Please visit bangaloreici.org and register for both these conferences, and you will acquire a lot of knowledge, and you can have the networking too. With that note, once again, hearty welcome to each one of you. Over to Sri Vijayshankar. Over to you, sir.
Good evening, friends. I will share my screen so that I can show my presentation, and then we'll start off. Okay, I suppose you're able to view the presentation.
Yes, sir.
Yeah,
it is
fine. So the topic for discussion today is data audits under PDPB 2019 and ITA 2008. As chartered accountants, sorry, I put ISACA, it's ICAI. As chartered accountants, you are all well versed with the field of conducting audits. But data audit is something which is, you can say, a new term which is coming into our profession. For example, in the Personal Data Protection Bill 2019, which is presently in the Parliament, and it has gone through 2 years of evaluation in the Joint Parliamentary Committee, and the revised version is likely to be presented in the next Parliament session, which is starting from November 29th. And my expectation is that in this session itself, the bill may be passed and it may become an act, failing which, of course, in the budget session, it should become an act. Most probably it will become an act in this December itself. But of course, after passing the bill has to be has to go through the presidential assent, and then there will be a notification. And after the notification, we are expecting that the government will give sufficient time for the industry to adopt data protection legislation. Therefore, from today up to the implementation, there is some time. People are saying that the government may give at least about 2 years time, because 2 years was the time which was given by GDPR and other legislations. But probably India may give slightly less. According to me, even 1 year is more than sufficient, because we have been discussing this act for such a long time that any further delay is definitely not considered good for the industry, because globally more than 130 countries have already passed data protection laws, whereas we have still been discussing. When Information Technology Act was passed, we were perhaps the 16th country in the world to have an act like that. But now we are already behind other 130 countries, and that includes even our neighbor Pakistan and China. Both of them have got data protection regulation. India doesn't have a data protection law, though India is the global hub for data protection. So therefore, the government should consider implementing the act as early as possible, and I feel that 1 year is more than a good time for implementation. But anyway, industry would like to have as much time as possible. So if they give 2 years, it is fine for the industry. Now, in this Personal Data Protection Act, there is one very important provision, which is that every significant data fiduciary has to conduct what is called a data audit every year, and by an external auditor. And this auditor has to give a report which should contain, in most of the cases, a rating called data trust score. And that will be something which the companies may have to disclose whenever they raise personal data from the market or to their shareholders. So that is a new system which is going to come in India. And just as today statutory audits take place in every company, and if there is a listed company, there is also a clause 49 declaration and so on. If an organization comes under the definition of what is called significant data fiduciary, then this mandatory annual data audit from an external auditor also becomes necessary. This means that there is a potential for business of that nature, and it is not possible that data audits can be done as an extension of the financial audits, about which you are all very well, you say you are well versed. And some of you may be even aware of what is called ISMS audit, that is the Information Security Audit, but neither the statutory financial auditors nor the traditional ISMS auditors can automatically become data auditors, and they need to actually learn something new before they can become a data auditor. Of course, along with this act, there will be an authority called Data Protection Authority, And that data protection authority may even have a system of accreditation for data auditors. So there is a lot of things which are going to happen in the professional scenario, but definitely this is a great career opportunity emerging for data audit, and chartered accountants can very well become one of the chief contenders for occupying that particular position. Additionally, any person who is working inside an organization, the Act also says that we have to designate a person as a data protection officer. Recently, they have also clarified that this data protection officer has to be at the senior level. In fact, he will be a person who is reporting to the CEO or even the board. We normally recommend that he should be reporting directly to an independent director in a governing council. Definitely he will be either on par with the CISO or even above the CISO. So it's a very senior position, and all organizations which will be called significant data fiduciaries will be required to designate a person as a DPO who should be an employee of the organization, and that person cannot have conflict with other duties in the company. Therefore, you cannot simply redesignate your CISO as CISO plus DPO or something like that. Therefore, DPO is also a career advancement opportunity in the organization. Sometimes the CISOs or the CIOs may be designated as DPOs, or the compliance officers may become DPOs. Now, even when there is a DPO within the organization, there could be possibility of external consultancy organizations trying to help the organization in compliance. Therefore, this data protection audit will become necessary to be understood by the internal DPOs and the CXOs. So this data audit is going to be very, very significant for the professional workforce. When we say significant data fiduciary, we are talking of companies who are primarily collecting and processing in some form personal data. And if the activity level of such an organization is beyond a particular threshold level, or if the type of personal data which is being processed is very sensitive, then such companies may become significant data fiduciaries under the law. And this mandatory data audit and appointment of DPO and several other things becomes necessary for such companies. Many of the medium-sized companies, of course the large companies, they all will be significant data fiduciaries. So therefore, there will be thousands of companies in India which will be looking to appoint data protection officers and conduct internal data audits, and also at the end of the year look forward to external data auditors to conduct their audit. So this data audit will become a very important thing for all the chartered accountants to work at. Now, when we look at data audit, just to understand the scope of something called data audit, we must remember that audit by definition normally involves verification and appropriate documentation. See, if it was mere verification, anybody can do it, but audit in our context requires documentation because it is further verifiable by the data protection authority. In fact, chartered accountants are very well versed in terms of documenting what they find in an organization, which technical people may find it still difficult. A CISO may do a data audit, but when it comes down to writing down a report, the skill of writing the report may not be there with the CIO and CTO. Therefore, the DPO or the data audit skill is something which requires the knowledge of law, knowledge of technology, and skills of audit, okay, plus report writing. So this is the data audit. It is not an audit about say whether an asset is there or not. It is not like just taking inventory. Of course, inventory of data assets is one of the requirements of conducting an audit, but that is not the end of it. Or like in the case of information security audit, it is not like just identifying what are all the different assets which are handling information and so on. It is much more than that. This data audit is an audit of compliance to a given law. So when we talk of PDPB related data audit, we are looking at an organization and finding out whether this organization is compliant to every aspect of the law as given in the respective law, which could be data protection law, which is emerging now, or even the Information Technology Act, which is already present. So to do a proper data audit, the auditor needs to have a good understanding of the law and also what is the nature of data. Without understanding the nature of data, you cannot apply the data related law. Now, when we look at data audit, the data audit can be conducted as a regulatory audit sometimes by the regulator. The perspective of a regulatory auditor is slightly different from the perspective of a person who is doing it as a self-audit in an organization, or a consultancy audit where a consultant is trying to advise a company about what to do. Regulatory audit is more like a fault finding audit. So they will look at either a complaint if it has been received, or sometimes, of course, the law will empower the Data Protection Authority to proactively choose a particular company and go ahead and do an audit. So proactive audit is possible from the regulatory authority, which will be mostly like finding the fault. And if it is based on a complaint, and if the audit finds some shortcomings, it could result in some kind of a penalty. A self-audit is conducted by the company. It is part of the internal discipline. So the internal audit teams should be capable of conducting the self-audit, which is a replication of what a regulatory auditor may do. A consultancy audit is one where a consultant tries to find out the shortcomings as of now, which will be what we call as gaps, and then advise the company how to fill up those gaps and be ready for a regulatory audit to be satisfactory whenever it is conducted. And this providing consultancy audit is one of the professional opportunities which emerge out of this new act. And regulatory audit, of course, the DPA will have its own team. Perhaps we will see how they will structure their audit team. Now, before we go deeper into it, we should try to understand that we sometimes use the term assessment along with audit. Normally, audit may have a reference point, and we are trying to see what is the finding of the audit, whether it is yes or no. So it's a binary result. So audit is normally a binary result. A company is either in compliance or it is not in compliance. Even when you break it down into a number of components, for each component, you find out whether the company is in compliance or not. Now, assessment, on the other hand, may or may not have a reference base. In fact, it is an open estimation of what is the maturity level of implementation, and it will be normally on a continuous scale, and in a way it is like a snapshot in this journey of an organization. But it is not a yes or no answer. It is that the company is in this particular status. Now, if the company says that I want to reach somewhere else, fine, then you have a further journey to achieve. So assessment is a kind of an evaluation on a continuous scale. Sometimes audit and assessment may have to be combined into a single exercise. You do an audit of what is the current status of the organization, and then also try to give some kind of a rating to the maturity level, to what extent they have achieved the requirements of compliance in terms of what could be considered as an ideal compliance level, and that is what is referred to as data trust score in the Indian law. See, GDPR does not have this concept of measurability of the data protection compliance. Indian law has this requirement, and in India this data in rising personal data from the public is more or less likened to the way companies raise money from the public. Say, when a company goes for an IPO and wants to raise money from the public, they are supposed to issue a prospectus, tell them that I want your money, I want to use it for this particular purpose, and this is how I am going to use it. Similarly, in the data protection area, companies are required to tell the public from whom they are taking the personal data and give them an information that I want your personal information, this is how I want to use it. In that process, they will have to tell them, just as in the case of an IPO, you tell them about the project, profitability, etc. In the case of data, you have to tell the public that this is how I am protecting your personal data in my custody. So therefore, if you are a person who is concerned about privacy, which is a fundamental right, which the Supreme Court of India has declared in the Justice Puttaswamy case, then this is how I am going to protect your privacy. And as a measure of that, this is the data trust score which my auditor has given. So just as you have got a credit rating for a debt instrument which you are trying to raise funds from the market, you speak of DTS score for a company which is raising personal data from the public. This is a beautiful concept, unmatched in the world, and that is why the Indian data protection law is a shade better than GDPR. There are people who think GDPR is the master of everything, but it is not so. Indian law is in many ways better than GDPR, provided we have a mind to look at the details and understand the beauty of this particular law. Now, in this PDPB 2019, there is one important section which we have to remember, that is called section 29. Of course, the section numbers may undergo a change if one more clause is added or something like that. But current section 29 of PDPB 2019 says that the significant data of fiduciary shall have its policies and conduct of its processing of personal data audited annually by an independent data auditor. So this gives some indication of what a data audit is, because that will include a verification of the policies and the conduct of the processing as done by a company. Now, this particular requirement has to be documented by a company in what we call as a PBD policy, that is privacy by design policy. So just as the prospectus in the case of a public issue, a PBD policy document has to be written by a company which proposes to take personal data from the public, and that PBD policy document has to be certified by the Data Protection Authority, and that becomes kind of say foundation for the activities of the organization and a future audit and so on. Of course, this is what is there in the current bill. Hopefully, this will remain even in the modified version, which will be available by next Monday, perhaps by next Monday or a couple of days later, when the bill is presented in the Parliament. That new version will become a public document. Until that time, we are working on the PDPB 2019, but the difference could not be significant because the principles of data protection will remain the same. There could be some minor changes in terms of procedures and other things. So this is the requirement which I am talking of as a mandatory data audit. For doing this, under section 29, the authority shall register in such manner, whatever they try to give, the persons with necessary expertise. What kind of expertise they are looking for these data auditors? They should have expertise in information technology, computer systems, data science, data protection or privacy, and possessing such qualifications having regard to the factors required, and of course integrity, ability, etc. As of now, privacy and data protection is a new subject, so you may not have a degree from a college which says that you are a data protection officer, but it will come sooner or later. But in the meantime, the industry-based certification programs are the best programs which the Data Protection Authority also has to consider to ensure that a person is capable of taking on this responsibility. Now, maybe in days to come, ICAI itself may try to develop some program. Right now, FDPPA conducts a DPO training which runs for about 30 hours of training. It is available presently on tap through streaming videos. And of course, from time to time, we may revise that by actual programs, particularly when major changes happen in the law around us. For example, when the new Data Protection Act of India gets passed, maybe we will have to revise at least a significant portion of our training, and at that time we will be conducting an online a program which may be still online, but it will be a proactive kind of a real-time data protection officer training. As of now, of course, it is available as a part of a training based on streaming videos. Of course, whenever FDPPA does any such trainings, if somebody has taken a streaming video training, we almost always, as a matter of rule, give them free entry to the immediate next training program, which is conducted as a real-time program. And therefore, anybody who takes the streaming video program now will also be automatically accommodated in the program in which some changes could be discussed if the new law comes in. So the Data Protection Authority may have their own systems, in the sense that, like in the case of a patent officer, the patent office conducts its own examination. Likewise, if the Data Protection Authority thinks of conducting their own examination, that is also possible. But we in FDPPA has already done this. For the last 2 years, we have been conducting such programs. In fact, our programs are ready to be rolled out even as part of the DPS program. Now, under this section itself, it says a data auditor may assign a rating in the form of a data trust score, and the authority will specify how such a rating could be provided. Here again, we have preempted what the Data Protection Authority may say, because we are already having a system of calculating DTS, and FDPPA, along with the DNV, which is a globally renowned certification agency, we provide DTS to the clients who undergo our assessment. Now, other than this, the same section 29 specifically lists out what are the requirements of a data audit. What it says is the data auditor shall evaluate the compliance of the data fiduciary with the provisions of this act, including this list of things. As you can see, the data auditor has to see the clarity and effectiveness of notices. Now we will discuss all these things in a little more detail later on, but I just want to give you a bird's eye view of what the data audit will contain. So, clarity and effectiveness of notices issued for collection of personal data. Now, there is section 7 which talks about what should be done, so this has to be in compliance with this. Similarly, there is a section 22 which talks about measures to be adopted by a data fiduciary for compliance. And under section 23, there is something about transparency. Under section 24, the security safeguards. Under section 25, how to handle data breaches. Under section 28, something more about the implementation of processes in time, and maybe any other matter as may be specified by the regulations. So why I'm showing this is that a data auditor needs to know what is section 7, 22, 23, 24, 25, 28 and so on, which means that without having a thorough knowledge of the Data Protection Act, it will be difficult for anybody to be an effective data auditor. That is why you need to study the data protection law. When we look at data protection law, the first and the most important aspect of application of this law is to find out to what kind of data this law is applicable. For that purpose, we must recognize that data consists of two major components. One component is called the personal data, and whatever is not personal data is non-personal data. Now, what is personal data is defined in the law. And it says that any information which is about a living natural person is called personal data. Note the words living natural person, which means that a person who is deceased, that information is not considered personal data as far as this act is concerned. Protection of that data may be relevant for some other law like defamation law or something like that, but Personal Data Protection Act considers the data of individuals who are living as relevant for this act. Now, it should have information about a person. So when we say information about a person, it could be his name, it could be his mobile, it could be his email address, it could be his educational qualification, health or finance information, and so on. These are all information about a particular person. Sometimes we also add technical information, what we call as metadata in the technology terms, like the IP address from which you normally access your machine data and so on. And there are also certain things like your religion, your caste, and sometimes your political opinion, religious opinion. They are all considered as personal data. Now, whatever does not come under the definition of personal data, the residual data becomes non-personal data. This non-personal data will consist of corporate data. It consists of data which is not related to an individual, like weather data or something like that, or industry data. And there is one type of personal data which, if you remove all the identity parameters irreversibly, it becomes an anonymized personal data. Anonymized personal data can also be considered as non-personal data because it is not possible to identify the individual behind an anonymized personal data. If the anonymization is to that standard, then the personal data gets converted into non-personal data. This standard also will be defined by the Data Protection Authority, which will convert a personal data into anonymized personal data, which becomes non-personal data. So this is the first thing you have to recognize, that in the data audit system, the first thing we have to do is understand that this law is applicable only to personal data, and therefore we need to segregate the data asset of an organization first into personal and non-personal data. When we talk of privacy as a concept, and we look at the Justice Puttaswamy case or something like that, that actually provides something like it's a human rights concept, because people say that we are a democratic society and our people, citizens, have a fundamental right. And what is that fundamental right of privacy, which Justice Puttaswamy's case has held as a fundamental right? It is the feeling of being left alone. See, what the court says is you have to protect the privacy. Now, what is privacy? Privacy is the state of mind of an individual, what goes on in his mind, because people may feel they are left alone when they are amidst, let us say, people who do not know who they are. For example, if we are in a crowded train or a crowded bus, we don't mind our privacy. We are feeling left alone, though people are physically near you. But at the same time, there are many instances where you are put into an isolation, but you are not feeling left alone, because that is a forced isolation. So this feeling of a person being left alone is the privacy, but that has somehow got translated into an IT concept where we use the terminologies like data privacy or privacy protection or data protection. Here, what we are trying to do is that this individual whose privacy has to be protected will provide his personal information, which is the IT element, and he will also tell the collector of this information that you are supposed to use my personal data only for this kind of a purpose, only like this. So that choice is given to the individual, and we as an IT company are supposed to see that this choice is respected and implemented, and that is what we call as data privacy, or any other term like data protection. We in FDPPI, personally I always try to make a small distinction between the terminologies, and we prefer to use data protection because when I say data privacy, there is a confusion whether data privacy means privacy of data, which is confidentiality, integrity, and availability of data, which is actually an information security concept. Therefore, data privacy is more appropriate to be used as an IS concept, and for which whatever we do in the organization, we call that as ISMS, that is Information Security Management System. Whereas what we are looking at now is data protection or privacy protection of the individual who is behind the personal data. So privacy protection is focused on an individual, information security is focused on the inanimate object called data. To keep this distinction, we try to use data protection as they protecting the privacy of an individual by following whatever measures are related to the processing of personal data. This, in terms of a system for compliance, is sometimes referred to as PIMS. We can call it as a personal information management system or privacy information management system. There is also a similar term called DPMS which has been used, but we try to use a terminology called PDP-CMS. In fact, the certification programs which we conduct end up certifying a person as an auditor for PDP-CMS or a consultant for PDP-CMS. Now, what we mean by PDP-CMS is Personal Data Protection Compliance Management System. This is the managerial architecture for compliance of personal data protection as per the law. So, PDP-CMS focuses directly onto the compliance of a personal data protection legislation, which may be to the PDPB 2019 or ITA 2008. So, ITA 2000, which was amended in 2008. So this is the concept of privacy which we as auditors need to understand. Now, if you look at the law of data protection in India, currently we have got the Information Technology Act 2000, which was effective from 17th October 2000, 21 years ago, which was amended in the year 2008, and this amendment became effective in 2009, and the notifications related to that came in 2011. So many people recognize this amendment as if it happened in 2011. It is in this amendment that the sections like 43 capital A, 72 capital A, 67C, 69, 69A, 69B were all introduced. And along with that, some of the earlier sections like 65 and even 72, the meanings changed because of the introduction of new sections. So these are all things which are existing today. Now the PDPB 2019 current version is in the Parliament. The draft is available. You can refer to that in the internet. So this is available and it is currently under discussion. Very shortly, this is becoming perhaps PDPB 2021 or whatever name is given. This is as modified by the JPC. Actually, I call it as JPC2 because earlier JPC had done extensive work for more than 1.5 years. Then because the chairman of the JPC, Meenakshi Lekhi, became a minister and somebody else like Rajiv Chandrasekhar also became a minister, the JPC was reconstituted with a new chairman, and therefore this new JPC also spent some 3-4 months in making further consultations, and after that now they have finalized and presented a copy to the speaker. The speaker is going to be to present it to the parliament when the particular session opens, and this is the final version which will be available shortly within a week. It may contain some changes with reference to 2019, but what we need to remember is that ITA 2000 had a section called 43A, and PDPB 2019 says that when PDPB 2019 becomes an act, it will replace 43A. That is, 43A will be deleted, and the new PDPB 2019 with 98 or 99 sections will come in its place, which means that PDPB is a seamless upgradation of Information Technology Act. Information Technology Act talks about protection of both personal data and non-personal data. Personal data protection is under 43A, 72A and so on. Protection of non-personal data is available under section 43 or section 66 and various other sections. So today ITA 2000 is a law which protects personal and non-personal data. Now, PDPB 2019 was envisaged as a specialized law for protecting personal data. Now, in this PDPB 2021, somehow a thought has come into the minds of the people there that this law should also incorporate some aspects of non-personal data protection. Of course, non-personal data protection is already there in ITA 2000. But what they may be doing is that in data breach notification, they may say that even non-personal data, when it is breached, a notification has to be sent to the Data Protection Authority. Maybe some 1 or 2 such points will be given so that when there is a need for a modified version of ITA 2000, which will address the non-personal data, maybe this Data Protection Authority of the current law PDPB 2019 will also be asked to take care of the non-personal data related regulation. As of now, a committee under the chairmanship of Chris Gopalakrishna had been formed, which had given a report for non-personal data governance. Okay, what was the difference between governance and protection? Protection only talked about how to protect the non-personal data, which is there in Information Technology Act, and protection of non-personal data is there in the PDPB. Governance meant that the Act will tell how the non-personal data could be monetized. So business people will be very happy to see that there will be a law for monetizing the non-personal data, and that was supposed to be done by the Non-Personal Data Governance Act, where also there should have been a non-personal data governance authority. Now what the current JPC has done is, instead of looking at one more regulatory authority, let us have this Data Protection Authority under PDPB, and maybe when this Non-Personal Data Governance Act comes, we will give that responsibility also to the same regulator. That is what may be happening now. Now, the difference between ITA 2000 and PDPB is that ITA 2000 is a cyber crime related law, which means that the penalties are applicable when there is a cause of action. That is, when somebody has suffered a wrongful loss and he is the victim and he invokes a complaint, either he goes to the adjudicator for civil remedy or he goes to the police for some kind of criminal remedy, then only ITA 2000 becomes applicable. Whereas under PDPA does not require a victim. It does not require a data breach. It does not require a crime to happen before invoking the provisions of the Act. It is a proactive, compliance-oriented legislation. Therefore, things like a company has not designated a DPO, but according to the Act, it was required. So that itself is sufficient to impose a penalty. A company is a significant data fiduciary, but the management is sleeping. They don't know that they are a significant data fiduciary. Then they are also liable. So in such cases, the There may not be any data breach, there may not be any cyber crime, there may not be any loss, but still the company may have to perhaps pay penalty, which could be as large as 4% of the global turnover of an organization. That is the level of penalty which is envisaged. Now, when you look at the data protection compliance audit, here itself we can make some micro classifications. One is, of course, the section 29 audit, which is the comprehensive compliance audit, where we look at how the consent has been obtained for collecting the personal data, what kind of notice was issued, security, incident management. These are the things which are looked at under the compliance law. There is a concept called harm audit, where we try to make an assessment out of a given context. The context may be a data breach, context may be a request for information from under a Right to Information Act or something like that. Whenever such an instance happens, we try to make an assessment. If I do this, what will be the harm caused to the data principal? Data principal is the person whom GDPR wanted to calls as data subject. Data fiduciary is the organization which GDPR calls as a data controller. In India, we call them as data fiduciary and data principal. Now, what is the extent of suffering which a data principal will have to face because of a data breach? That is what is called as harm audit. Harm is also classified into significant harm and so on. So that is a kind of audit. Then data breach audit is one where a breach has happened. Now you have to find out who are the persons who are affected, what is the extent of the effect, what is the cause, what action to be taken, and so on. I will address the questions later, but I would like to complete the thought process. Okay. Now there is something called data protection impact assessment, which is normally undertaken when a new process is being adopted, where the company or the organization has to make an assessment of this is a new process. If I start using it from tomorrow, what will be the effect on the data principal? Now, after conducting a data protection impact assessment, sometimes the organization may have to seek the permission of the data protection authority if there is a doubt that there could be a significant harm. Otherwise, they have to document it and present it to the DPA at some point of time. Then we will be having the contract related audit, which is the company's contracts with various people. For example, the data fiduciary has got a contract with the data processor, and the data principal and the data fiduciary agree to share the information, which is also a basis of a contract. So there are several things which comes under contracts, because if I am a data fiduciary, I am expected to be compliant with the law. If I make use of a let us say data processor as my subcontractor, I should have a data protection related contract. In fact, it's like a business associate kind of a audit where the compliance by subcontractors is mandated into the contract, and the data fiduciary also retains the power to do an audit, and when an audit of a subcontractor is done, that is called the BA audit. Therefore, the data protection compliance audit itself may take different, say, colors, like the total compliance audit under section 29 for the organization. Within that, a harm audit, data breach audit, data protection impact assessment, a contract audit, and the business associate audit. So a data auditor must know what are these different kinds of audits and how do we distinguish these. For example, if you are looking at a compliance audit, this is law-centric. Why I say law-centric is you have to evaluate whether the provisions of the law have been complied with by this organization. Of course, it may also involve measurement, as I was telling you, the DTS. Now, this could be mandatory on an annual basis. Internal audits may have to be conducted under the same principles, so that when an external auditor is invited, he is having some information that, okay, I am coming after 1 year, maybe mid-year, after 6 months, there is an internal audit. They may look at what was the findings of the internal audit. This is an elaborate audit. It encompasses the data protection impact assessment audits done during the period, harm audits done during the period, data breach audits which might have been conducted during the period. All that is integrated into this compliance audit. It is done normally by an external auditor and of course replicated by the DPO, so that you will not be surprised by an external data auditor. Now, harm audit on the other hand is data principle centric. That is, you have to put on the hat of a data principal and empathize with him that this particular incident, what has happened to me, let us say my credit card information has been leaked. Now, what is the impact of that? Will I suffer any financial loss? My password has been lost, because of which am I going to lose money in my bank account? So that kind of harm analysis will have to be done, and that is the harm audit. Independently, harm audit is required whenever conflicts of interest has to be resolved. Like I told you, right to information, somebody asks for information, then you know that if that information is normally, if it is a personal data related information, the information person in charge may say that it is personal information, it comes under the privacy regulations. But the right to information may require the private information also be provided in certain times, and at that time this harm audit has to be done. You have to document that, and even when it is necessary to go to an adjudicator to get a decision on whether I should release this information or not, this harm audit document will become very useful. And what is a harm is defined under PDPB 2019. It includes bodily or mental harm. You're all aware that nowadays we are having medical implants in the bodies of individuals, even wearables. Wearables do the ECG, and medical implants like the pacemakers actually are providing a lot of information. Actually, that information doesn't stay inside. It is connected to an external device and it goes to a doctor or something like that. So that is personal information, because once the device ID is there, the pacemaker number so and so, the hospital or the doctor knows this belongs to that XYZ person. So this is a personal information, and therefore if there is a malfunctioning of that, or if that data is leaked and somebody makes adverse use of that, there could be a bodily harm also. Mental harm, definitely it could be there. Loss of job could be there. So many other kinds of harms. The consequences of a data breach are all things which have to look will be listed as harms, and significance of the harm may have to be assessed. That is harm audit. Data breach audit is incident centric. That is, on a particular day you are reported that some data has been leaked because somebody says that in dark web I saw a set of data belonging to your company. So that kind of a thing is a data breach related situation where you do an audit even when there is a suspected data breach, and sometimes these things come to your knowledge through a whistleblower. Then in such cases you have to evaluate what is the nature of the incident, its impact in terms of who is affected, how many people are affected, what kind of harm is caused, and of course who is responsible, because that also is required for imposing penalty. This should be done by the data protection officer with the assistance of the information security people, and if necessary you can take the assistance of external forensic investigators. So that is data breach audit. Data breach has to be reported by a data fiduciary to the data protection authority within 72 hours, and certain times it may also have to be reported to the data principals. Okay, in what cases it is to be given to the individuals and what cases it has to be given only to the data protection authority, details we have to see the extent of harm which is caused. Now, the data protection impact assessment is a process centric thing. That is, there is a process, and if that process is implemented, there is likelihood of some harm. So assessing that and then trying to give a sort of a permission to use a particular process, that is data protection impact assessment. So these are all the ways by which you should look at an audit. Contract audit, of course, is document centric. You are examining the particular contract, the objectives, who is the person who has executed it, and whether the roles of people are properly identified, whether data protection clauses are included there, and so on. Now, business associate audit, as I already said, it is the audit of a third party who is our service contractor. It is relationship centric. Now, coming to this Information Technology Act 2008, here also we look at a compliance audit. Of course, this is 21 years old, or at least you can say from 2008 or 2011, this has been in existence, though many companies have not undertaken ITA 2008 audit, but in respect of UADAI somewhere, and even banks, ITA 2008 audit have been made mandatory. So some of them have at least documented the audit. Here, what we do is ITA 2000 or the 2008 version of it is actually a cybercrime law. Therefore, there are number of sections in which it is said that if you do this, there will be a civil liability. If you do this, there will be a criminal liability. Now, from the perspective of compliance, what we are trying to say is, if something is stated as leading to a civil liability, from compliance point of view, we should avoid doing things which is a contravention. Similarly, if something says that it will lead to a criminal punishment, it means that from the compliance angle, I should not do that. So the compliance manager has to extract from the penalty sections of Information Technology Act the various requirements which are likely to result in some kind of a compliance requirement. If you just take a quick overview, there is data privacy risks which are arising out of non-compliance of section 43A, section 72A, section 66 and 43. Similarly, for data retention, ITA 2000 says something in section 67C and 65. If it is not done according to that, it becomes a risk. So compliance manager has to say what is the section 67C, what is section 65, and then try to be compliant with that. Similarly, there is an information demand risk which is stated in section 69, 69A, 69B and 70B. And if it is not properly complied with, it raises a 7 years kind of penalties. Authentication risk is the use of digital signatures or not using digital signatures. A risk arises because contracts get consummated without proper authentication. So therefore, that is something which has to be taken as a compliance requirement. Similarly, there is a specific section called 7 capital A in Information Technology Act, which is actually saying that the data integrity of the organization has to be audited, and if of course the audit of such data was necessary in a legacy paper-based system, and that is the e-audit risk. Then e-contract risk, when contracts happen when you don't want to happen, contracts don't happen when you want it to happen. That kind of a risk by non-compliance of specific sections, you look at it as a e-contract risk. Beyond this, all these penalty sections which come under Chapter 11 of Information Technology Act, normally it is meant for somebody who commits a crime. And a crime normally has to be accompanied by mens rea, that is the guilty intention. So a company can always say, I never wanted to commit some crime, but my employee did it, and my employee used my computer to commit a crime. In such cases, the organization will have to face what is called the vicarious liability risk, which has to be covered by the principle of due diligence, which is there in section 85 and section 79. Now, we say that this due diligence requirement also extends to the section 43A, which is being replaced by PDPB. Therefore, this PDPB 2019, whatever is presently there as a draft, is actually a due diligence requirement under section 43 capital A. That is why we say that PDPB 2019 is already in place and is required to be complied with. And even if the government gives another 2 years time for actual implementation, it only means that penalties under PDPB 2019 will not be imposed for 2 years, but compliance is still required. In fact, there are many court cases which have happened in the last 6 months or 1 year where courts have been quoting from PDPB 2019, which is still a bill, and they are saying that this is stated like this, you did not do something like that. So the courts have already started recognizing PDPB 2019 as part of the requirement, and therefore we say that PDPB 2019 is already in existence today. Now for ITA 2000, we at the FDPPA have developed our own system of compliance framework, which we have called as DPSI, which is a Data Protection Standard of India, which is a 33 control mechanism, which has management controls, legal controls, HR controls, and technical controls. I'm not going into the details of this, but this covers all aspects of ITA 2000 required as compliance measures for meeting this kind of risks which I have highlighted here. Now we will get into the PDPB. Okay, just to understand the PDPB risks, I will quickly go through the PDPB. It's a law, therefore it requires a more detailed discussion, but let me try to quickly give you a bird's eye view of this. PDPB 2019 at a glance, if you look at it, it contains several chapters. One chapter on definitions and applicability, then exemptions which go along with its applicability, then obligations of the organization, rights of the data principle, children's data, how it has to be handled, transfer of data outside the country, or what we call as data localization, then how to handle data breach, how to handle grievances. These are all covered under PDPB along with the penalties and the portion related to regulatory authority. First, looking at the penalties, I would like to draw your attention to the fact that penalties presently are based on turnover. This turnover concept was introduced by GDPR. They classified certain contraventions requiring 2% of the global turnover. Certain things where 4% turnover was there. These were retained in our PDPB also, along with the financial limits. 5 crores or so and so, whichever is higher. 15 crores or 4%, whichever is higher. There is a press report or a rumor which says that the JPC2 has tried to remove this percentage wise calculation, and it may only talk about the financial limit. It may not be 5 crores, it may be 50 crores. It may not be 15 crores, it may be 100 crores, but it will not be related to percentage is what the newspapers are presently talking of, but it may not happen. They may retain this percentage way of calculating the penalty. Remember that in one of the GDPR cases recently, Amazon has been fined. Of course, it has not yet been actioned, but it has been fined something like 887 million US dollars as fine, and Google has faced up to 50 million US dollars. Then Facebook has been facing one penalty after another. They have made a provision of 334 million US dollars in their books to meet the GDPR liabilities. So the level of penalties is so high that companies may find it an existential issue if they are non-compliant. Same thing can happen in India if this turnover-based penalty is retained. Other than that, of course, per day limits are there, whereas government bodies, since turnover concept is not applicable, for them the maximum of 5 crores was there. There is only one section under PDPB 2019 which has a criminal punishment for 3 years. This is applicable for re-identification of de-identified information. I will address some of the questions if you want more clarifications after going through this general principles. Now, when we look at compliance requirements, what PDPB says is that you please understand what is applicable. then follow the data protection principles stated in the Act. And one of the important principle is that there are certain rights available to the data principles which have to be integrated into the principles. Security has to be maintained. Cross-border limitations will have to be ensured. And then you also need to have a privacy by design, which is end-to-end compliance with appropriate documentation. This is as far as the compliance requirements are concerned. Now, as far as the accountability is concerned, we need to look at the roles. Data principle is the central focus of data protection, and the organization which principally determines how the data is collected and processed is called the data fiduciary. The word fiduciary means that he is the trustee of the data principle. He is not just a controller, he is the trustee. Trustee has got more responsibility than the controller. Controller can say, you have given me this contract, I have done a checklist kind of a thing. I have done, you have asked me to do this, I have done this, checklist, like that. That is what many of the auditors do. But in the data fiduciary concept, if the fiduciary thinks that something which the data principal wanted me to do is not in his interest, then the data fiduciary should be able to take that into account and perhaps, if necessary, ask the data principal once again. This is like the management of a portfolio of a minor or something like that. So that is the concept of data fiduciary, which is there in our law. And the fiduciaries who handle minors' interest, they are called guardian data fiduciaries, and those who handle large data sets, they are called significant data fiduciaries. Both of them will require prior registration with the data protection authority along with various documentation. Anybody who does the processing on behalf of data fiduciary is called the data processor. Now, in addition, the Act also recognizes a particular role called consent manager, who is a person appointed by the data principal under something like a power of attorney to deal with the data fiduciary. He is also a data fiduciary, but he is a data fiduciary who is appointed by the data principal like a portfolio manager. Now, he will in turn deal with the data fiduciary and provide whatever information the data fiduciary would otherwise collect directly from the data principal. He acts as the buffer between the data principal and the data fiduciary, because India has a specific problem of languages. So if there is a privacy policy, people are not able to understand it, education level is low. Therefore, the Act considers the need for an intermediary called consent manager. In fact, some of the intermediaries who handle the news items, they are called social media intermediaries. Some special provisions could be there for them. So these are the kinds of roles which you have to identify your customers. Okay. Now, as far as the applicability is concerned, okay, data protection law in India is applicable to all types of entities, government, commercial and non-commercial. Unfortunately, some people don't remember this, and they are asking that NGOs should be given and other things. NGOs are already there. Educational institutions are there. Trusts will also be there. So all types of entities who are collecting or disclosing or sharing the personal information in India, they come under the Personal Data Protection Act. That is, those who collect personal data. The anonymized data does not come under these provisions. Non-personal data does not come under these provisions. Now, if there is a company which is registered in India, constituted in India, but they are collecting information not only in India but outside India, they are also coming under PDPB, but there could be some exemptions granted to them on specific application with reference to their non-Indian activities. This is again an innovation which has been given in Indian law. GDPR does not recognize this because they have not thought of the possibility that some of their data controllers could be actually processing data of other countries, and the local government or EU does not have any reason to worry about how the privacy of somebody else is to be protected, particularly when the other country has its own laws. If Canada has got a law to protect its citizens and we in India are processing the personal data of a Canadian citizen, then obviously priority should be to protect it as per the Canadian law, not according to the Indian law. This provision has been considered in our law. But if there is an organization which is constituted outside India, they may sometimes come under PDPB, provided they are doing business connected with any Indian activities which involve systematic collection of information, offering of goods and services. This kind of extraterritorial jurisdiction is there in GDPR. We have also adopted. So leaving these things, basically all companies, non-companies and other entities in India who collect personal data, process that personal data, store it or disclose it, they are all coming under the PDPB. Now, as far as the data principles rights are concerned, these are some of the rights recognized by the Act. That is, every data principal is expected to be able to get some information about what is being processed, get access to that, and if there is any error, get it corrected, and if it has to be deleted, get it erased, and he also has got the right to withdraw the consent, transfer it back in terms of portability, and lastly, there is a right called right to forget, which Indian law says that it will be only based on an adjudicator's reference. So right to forget is subject to the concurrence of the adjudicator, whereas in GDPR there is no such quasi-judicial intervention for right to forget. So if a terrorist has done something and he wants to remove his personal information, under GDPR you can very easily get it removed. If he sends a notice, as long as the data controller doesn't know that he is a terrorist and whatever activities he has done is likely to become evidence for a major terror kind of a investigation, the company will quietly remove all the data and in such a manner that it will never be recovered. Whereas in India, we have looked at such possibility and said that right to forget will be exercised only with the intervention of a judicial authority who will go through the legitimate interest of the organization as well as the national security reasons. So these are some of the things which we need to remember when we try to look at the Indian law. Many people have a fancy to criticize Indian law, but Indian law is far better than GDPR, just in the context. Now, in terms of principles, every organization, a data fiduciary, has to process the information lawfully with reference to the specific purpose for which collection is made with a consent. Consent is a necessary aspect, and only that information which is necessary should be collected. We call it as collection limitation. Notice should be something which the person can understand. Then quality of data in terms of accuracy has to be maintained, and retention should be only for a certain period of time which is necessary. And for all this, the organization is accountable. Now, consent is a contract. Notice is the offer. It has to be a free consent like any other contract. The burden of proof that a consent has been obtained lies with the data fiduciary, and the person who has the power to withdraw the consent, but he should not unreasonably withdraw it. That is one of the requirements of our law. If he unreasonably withdraws it, you can collect some charges associated with that. But there are also many provisions under which data can be processed without a consent, basically by the government for law enforcement purposes, courts, medical emergency, and so on. But in certain cases, even companies have been given exemptions for employment purposes, like by the recruitment, termination, performance assessment, attendance verification, and certain other reasonable purposes which include information security, prevention of fraud, or what can be claimed as legitimate interest of the organization, public interest, and so on. So these are things which the auditor will have to look at before coming to a conclusion whether the consent was proper or improper. Now, otherwise, national interest and other things are there, and these are the things which are normally discussed in the media, saying that the PDPB is heavily in favor of the government, which is not a realistic way of assessment. Now, in terms of accountability, an organization should have a data protection officer, should have a grievance redressal. It has to look at privacy by design as a policy and take care of transparency and security. Whenever data breach is there, notification has to be given. Data protection impact assessment has to be conducted when required. Maintenance of records are to be done. These are all the accountability factors of a data fiduciary. Other than data fiduciaries, data processors have to follow the instructions of the data fiduciary. This privacy by design policy is a comprehensive document which should have all the managerial, organizational, business practices along with the processes. I told you this is like a prospectus, so it is a comprehensive document. A DPO is a very unique structure who has to monitor the data processing activities of the organization. That is why he has to be the senior person. He has to also maintain records. He has to provide advice to the organization. And he also has to deal with the data protection authority and assist him. And he also has to deal with the data principles. So he should have the skills of handling grievances, the skill of managing the regulatory authority, besides the internal skills. That's why data protection authority is a very important kind of a role. Then we will look at the responsibilities of the DPO. The cross-border related issues. Basically, today our law is very lenient on cross-border transfer. Actually, only critical personal data should be processed in India. But even there is an exemption that for health emergencies, you can transfer even the critical personal data outside India. Then certain data will be classified as sensitive personal data, which may be transferred, but a copy has to be kept in India. Non-sensitive personal information, there is no restriction. Sensitive personal data includes financial data, health data, genetic data, and so on. So this is the cross-border transfer requirements. One of the changes which the government of India is likely to have incorporated in the latest version is that if some sensitive data has already been transferred outside, that is the legacy data which is lying outside, within a stated period of time, the organizations have to bring back that data into India. So this particular cross-border transfer in the new PDPA may have retrospective effect. Okay, so this is about cross-border transfer. Now, having discussed so many complicated things in data protection, your question will be also, are there any frameworks which can be used for compliance? Now, compliance of GDPR or what we call as ISO 27701, which is specially done for compliance of GDPR, is in my opinion not sufficient to be compliant with the PDPA, because PDPA is different. I have already mentioned some of these different things. That is the data fiduciary having a duty to care, classification and registration of data fiduciaries as significant or guardian, which is not there in GDPR, privacy by design policy document to be created and certified, consent managers system, social media intermediary system, sandbox system, DPO to be an employee. Like that, there are 7-8 major differences between GDPR and our data. Therefore, ISO 27701 falls short of the requirement. So, having recognized this, whatever you try to do in terms of segregation, identification, etc., you need to actually look at a compliance framework which is more suitable for Indian PDPA. Otherwise, you will be trying to fit a square peg in a round hole if you are trying to look at 27701, which is always implemented along with 27001. That is why we have created a specific framework called PDPSI, which is a unified framework. What we mean by unified framework is an Indian company normally is exposed not only to PDPA but also to GDPR and other laws. So there has to be one framework for multiple laws that is being accomplished in PDPSI. In the Indian context, of course, it will be extended to the DTS. So this PDPSI is the system which we are recommending, and it has got 12 standards and 50 implementation specifications. And the systems like ISO 27001 address ISMS, and ISO 27701 address PIMS. There is an Indian version called IS 17428 which addresses same as PIMS. They have called it as DPMS, but we are using PDPSI for the PDPCMS system, that is Personal Data Protection Compliance Management System, not for Information Security Management System or Personal Information Management System, but Compliance Management System. And this incorporates the best practices of other things. Therefore, it is what we call as essence of the essential, but different by far. And Indian companies need to work on PDPCMS. 27701 is like an extension built to 27001, whereas what we have created is directly applicable to the both the privacy and security requirements of the Indian requirement. So let me not go into the details of this, but I would like to assure that we have taken into account the management, DPO, legal, HR, IT, different requirements. We call this as responsibility distribution. It is not only the DPO who is responsible for everything. There are several other people. This is a distributed responsibility concept which we are using, which is very interesting for those of you who are perhaps going through it in detail. I will not go into it, but there is a DTS assessment also which we do. We identify all the risks, assign significance score, we apply mitigation effect, and then assess probability, and then calculate the DTS in the aggregate. And that means that at the end of an audit, we will come with a particular number saying that the DTS score of this company is 65.5. So something like that. So that is the beauty of PDPSI. Now, learning about PDPA and this kind of a system is unavoidable as of now for all auditors and those who are working in corporate environment. For me, it is exciting and challenging. For you, it could be an opportunity to break out in a career, and it could also cause a career slippage if you ignore it. So my thought process is, let us be ready before the act comes into force. So friends, I will stop here. I know I have given quite a lot of information, but we will spend the next half an hour for questions. I am sure that you will be having a lot of questions in your mind, so that we'll go back to any clarification which is required. Okay. Yeah, if somebody can collect the questions and let me know, it will be easier. Yeah, any questions? One of the questions which I see is from Rajagopal Tirumalai. At present, what is the qualification required to become a data auditor? As I told you, a data auditor should have the knowledge of the law, knowledge of technology, and he should have the necessary skills. So there is no degree or anything. The qualification is defined in terms of the functional requirements. And it's possible that after the DPA comes into existence, they may come up with some kind of a, let us say, a guideline. Until such time, we have to go by what is the functional requirement. DPO needs to handle the grievances, so he should have the capability of dealing with individuals. You know that individuals, when they bring complaints to the organization, many times they are unreasonable. So if a CISO or somebody is there, he gets irritated with a question being put to him, he will find it difficult to be a DPO. So he should be able to handle individuals. The old man who talks about his privacy being lost when actually nothing would have happened. And at the same time, he has to deal with the Data Protection Authority. He has to sit with somebody like the TRA chairman and then argue that the data protection impact assessment created by his company is good enough, whereas the committee there, the Data Protection Authority, may be challenging that your company has not done a proper DPIA. So this person should have the skill and ability to deal with the regulatory authorities. Beyond that, within the organization, he has to deal with the vice president business who wants to take a business, but you feel that it will be infringing on the privacy, you cannot take that, or you have to put in so many controls, etc. So you have to be able to put across your thoughts to the senior persons in the organization. So it requires a lot of man management skills also. So these are the qualifications which you have to look at from the DPO. Any more clarification you want on that? Mr. Rajagopal, you may have to unmute and then ask, or at least put further questions in the chat box. Yeah, Mr.
Other questions, sir.
Yeah.
I think you answered in detail. That is enough.
Yeah.
So I think
next
you
if data...
completed your presentation, sir, or still?
Okay, I will pass it on to you. Okay. Now, if data breach occurs, what are the penalties for companies whose registered office does not present in Indian location? As I told you, there is extraterritorial jurisdiction for the companies who are collecting data from India. There will be no difference between a company registered in India, a company outside India. So they will also be liable for the same kind of penalties, provided the data breach can be linked to some kind of non-compliance. Of course, even when a cyber crime happens, there could be, it could be considered as lack of adequate security. So many times in the GDPR scenario, we have seen that when a sophisticated cyber crime happens, also the company has to pay penalty. But maybe in certain cases where there is no negligence of the organization, there may be a reduced penalty. But if negligence is found out, or if non-cooperation is seen, then the regulatory authorities are normally very strict and they impose large penalties. And if the penalties are on turnover basis, that to global turnover basis, there could be the penalties at a very large levels. Of course, one possibility is that when the penalty is large, it will end up in litigation, because no company is going to just pay it up. They will go to the High Court. They will have to first go to the adjudicator. From the adjudicator, they have to go to an appellate tribunal. From the appellate tribunal, they will have to go to the Supreme Court. So litigation in India is very easy, and it is normally adopted to stretch the penalty payment time limit. It will be used by most of the companies. So that is one of the reasons why some people in the government felt that this percentage basis of a worldwide turnover, tomorrow you have to decide what is worldwide turnover, which should be included, which should not be included, your other concepts for taxation where you take into account the presence here, etc. It is going to be a nightmare to determine what is the global turnover of a multinational company, which has to be brought in to find out the compensation under a data breach which happens through a negligence in India. So it could be a good kind of a thing for say litigation. So that's why I think some people in the government, in the committee, felt that instead of that, let us say 500 crores, let us say 1,000 crores and get it away with it, not go into this calculation on the basis of turnover. But we don't know whether that idea will be accepted or not, because some of the JPC members have said that you want to avoid 2%, 4%, because you want to actually provide some concession to the industry. They have not looked at what I am saying, that the possibility of litigation being extended in the interpretation of what is a total turnover, worldwide turnover of, say, Amazon, say Google or something like that, because Google will have a Google India, Google France or something like that. There will be companies registered in various countries. Now, whether they have to be brought into this turnover or not is not an easy decision even for the courts. So it will be an extended discussion on what is the global turnover, what is the basis of penalty. And to avoid that, if they say that maximum penalty is 500 crores and the adjudicator says I will put 250 crores, then there is no discussion on the how that 250 crores was perhaps came into being. Mr. Rajgopal has put one more question, whether CAs involving this kind of data audit is considerable or still in the beginning stage. It is below beginning stage according to me, because CAs are busy with their financial audits. Now you have to tell me, you are from the community. Okay. So whether you have studied Personal Data Protection Act so far. If not, of course, we have in our FDPPA membership, we have a few chartered accountants also, but it is far less than what it should be, because all practicing chartered accountants are busy with their current activities. Only when I am saying that this will, your clients will tomorrow ask, are you doing a data audit? If you don't do it, I will ask somebody else to do it. Then you will start understanding the need to actually build this capability also into your portfolio, or at least how you get relationships with various other organizations whom you can invite to handle your clients. These things you have to look at it. But chartered accountants themselves, I don't know, they are not yet ready for this. And anyway, Mr. Shetty can tell me if whether they are ready.
No. Yes, see, for that we have the ICI come out with the networking concept. Because see, every aspect of law we cannot specialize. There are specialists. They need to put a lot of time and energy to become a specialist in that. And these are all specialized jobs. There are, I think, certain chartered accountants are interested in that. They are specialized. In addition to chartered accountants, ICI is now allowing to have a association with the engineers, architects, like that. So it is possible, so we can network with such professionals and take up the audit whenever the requirement comes. Yes, it is a coordination job. Even CS can also add value there. When the data specialist, while doing the audit, CS can also definitely add value, so that end result will be definitely a fruitful one. So that is the work I can say. So I have a question, sir, particularly when it comes to sensitive personal data. So it needs to be stored in India. That's what I heard. Is that strictly implemented as of now, or is still it is stored anywhere?
No, I told you that a copy of the sensitive personal information has to be kept in India, which means that you can also process it outside, you can also store it outside as long as you maintain a copy. Okay. Personal data which is non-sensitive, even that restriction is not there at present, but again, going by the last couple of days press reports, the possibility that the requirement of a copy of personal data also to be kept in India is very high. So there is no prohibition for transfer, but you have to keep a copy in India. The idea is that India as a country, our law enforcement should have control over this kind of an asset. Okay, tomorrow if it is required, then we should not be at the mercy of the US company or US regulatory authority to provide that information, because Googles and others will simply say, in my country, I am not allowed to give you the privacy. For example, today, if you look at a Gmail, okay, if you receive an abusing email from somebody into a Gmail account, then is it not your right to find out who has sent you that email? What is the IP address from which it has been sent? If you ask Gmail, Google, that I would like to know the IP address from which this particular email came to my legitimate email address, they will immediately say, I'm sorry, I am protecting the privacy of that person. I am not going to give you the IP address. So privacy is often used to protect the criminals. If you want to get that information, you have to go to the police, file a case, and then ask the police to issue a notice to Google, and by the time it happens, one, that IP address would be no longer relevant, or the effect of the crime is completely gone. So same thing happens in the case of domain names. If you look at domain names, say normally in the earlier days when some crime happens in a domain name, we used to immediately look at who is data to find out who is the owner of the domain, so that I can go and file a complaint in Indian court or police. Today, you don't get the details of the owner of a domain name, because that registrar says, I am protecting it for privacy. And many of these domain name registrars are not in major countries, so there is no way you can get the information from them. There are email providers like Proton Email who are actually meant to actually protect the identity. They all take the you can say loftier ideas that we are protecting privacy, but what they are protecting is the privacy of the criminals. And unfortunately, these Indian law enforcement people are having a lot of challenges in solving the cyber crimes. That is why there was a demand that a copy of this data, at least what is collected in India, should be kept in India, so that if necessary we can go to a court, get a warrant, and then get the information. So that is likely to be there. So both personal data and non-personal data copy may have to be kept in India. And one new provision which we have seen, as I told you, is that they may say, they may specify a time period and say in the last 3 years, whatever personal data has been collected in India and transferred outside India must be brought back to India as a copy within the next 6 months, 1 year, something like that is likely to happen, which is something which is actually extremely good. Okay, that thought was not there earlier about retrospective effect, but the new JPC has got that particular thought. If it is implemented, I would be very happy, because law enforcement would be happy to have the database, because in our case, India, crimes actually don't open up 2-3 years after it has happened. In fact, security people themselves, they say that when a data breach happens, it takes 6 months for them on an average to detect the data breach. And after that, if somebody goes to the police and files a case, by the time charge sheet is prepared and then some evidence people are looking at, it will be 1 year or 2 years down the line. So therefore, there is a need to have an archival of data for evidentiary purposes. And Indian law has recognized that that will be one of the compliance requirements, to have a data disclosure policy or data retention policy which takes into account the legal requirements. Even in Information Technology Act today, a minimum retention is 6 months. For example, if an app owner has given a mobile app and you register the app now, after 2-3 minutes after going through the app details, you think that it is no longer good for you and you uninstall it. But your installation information should be retained by the app, that app owner, for a period of 6 months for evidentiary purposes. But that has to be archived, not used, because the purpose for which you gave the information was for the use of the app, and now you have deleted the app, so you are not using it, so that information cannot be used by them, but they have to keep it in storage safely for 6 months. That is the kind of retention norms which Indian law is trying to give.
Yeah, I think you explained in detail. So, no other questions. You have any received any direct questions to your mail, sir? There Q&A. Some people directly post it to you.
No, because I'm only looking at the chat window.
Yeah.
And
Q&A also is there.
Q&A, yeah.
At the
Okay.
end,
No,
there
yeah,
will
yeah.
be also, no? Yeah.
Q&A, one question is there. Satyanarayana, PDPB will change corporate culture in coming years. Yes, certainly. And chartered accountants will be the people who have to guide your customers in this. So you need to actually be ready to be consultants to your corporate entities. Yeah, that is not a question, that's only a statement. So that is from the Q&A. Okay.
Yeah, that's all. I think you answered everything. You have abundance of knowledge in this area. I think we are really thankful for sharing this with us. So you covered almost all areas, including the various rights and duties of the agencies like data principal, data fiduciary, data processor, consent manager, intermediary, social media intermediary, and the protection of personal data, non-personal data in detail. So the various obligations, rights of the individuals, all these things. And finally, in case of data breach, what are the penalties leviable? Currently, it may be in a percentage wise, on turnover wise, as you rightly said, maybe in the coming act, they may crystallize the figure. So that may be a good idea. So I think one more chat, something has come latest. I
Yeah.
think he thanking the speaker. I think that's all. So otherwise, we had a fabulous session. So thank you very much on behalf of Bangalore branch and on behalf of all the participants here. Thank you very much. We had a fabulous session in detail. So we'll see you, request you to come some more time in the future once the act comes, that personal data protection bill becomes act, hopefully in this winter session. So after that, we'll go through once again. Thank you very much. Participants, you are the reason your active participation made this event a successful one. Thank you very much your active participation. Once again, I remind you for the day after tomorrow's program. It is Friday, Saturday, 2 days conference. So I request all of you to register. Please visit bangaloreici.org. It's a very, very important conference available both physically and virtually. Request you to register that program. Thank you very much once again. Thank you very much, Vijayshankar sir. Thank you very much on behalf of Bangalore branch and all the participants.